Appeals is now in session. Please be seated.
Good morning. Welcome to the Utah Court of Appeals as we take our show on the road today up to the University of Utah's Law School. We're very excited to be here. I'm Judge Ryan Harris, and with me are Judges Greg Orm and Ryan Tenney. And we appreciate Lisa Collins and the staff here at the university for making us feel welcome. I guess I wondered why I got picked to be in the middle here since I didn't go to law school here, but then I thought neither did these guys. So I guess the connection is at least I teach up here now, and I got to give a shout out to my 7 Civil Procedure 2 students who've been with me since 7 o'clock this morning. I think some of them are here. So anyway, thank you for being here. And anyway, welcome to all of you for our Court of Appeals arguments today. We've got 2 cases on the docket this morning. The first one is State versus Begay, and then we'll follow up in about half an hour or so whenever we're finished with that first one with Hallett versus Tolley. So let me call the first case and ask counsel to state their appearances, and we'll see if we have any questions before we begin. State versus Begay is case number 20230228. And let me get appearances from counsel if I might. Morning, Mr. Stewart.
I am an assistant solicitor general of the state.
Morning, Mr. Nelson. We appreciate both of you being here and varying your routine a little bit as well to come and do our argument here at the law school. Are there any questions before we begin? I've got a clock in front of me. I think there's one on the podium there. 11 minutes is what my clock says. Does that mean you've reserved 4 for rebuttal? See, quick math there. Okay. All right. Mr. Stewart, we look forward to your arguments.
Your Honors, counsel, may it please the court. We come before the court on an interlocutory motion from a request to dismiss Mr. Begay's case for a violation or for a statute of limitations issue. Our motion was denied by Judge Maynard, and that's why we are here today. I would like to start with pointing out some of the logic behind Judge Maynard's decision and why we believe that decision was made in error. First, to take a step back, I should state that the state and I agree with just about everything in this case regarding the statute of limitations that should be applied, regarding the green test that should be applied to determine whether or not a report was in fact filed and whether or not that report in fact began the statute of limitations. So we agree on all of those things. I think the real differentiation between my position and the state's is the third point of the green test. And that third point of the green test, in order to determine what a report is to start the statute of limitations, requires that the information regarding that the report actually communicates information bearing on the elements of a crime. So what Judge Maynard told us in his decision of the district court is that he said it was a very close point, but that saying terms such as rape or that a rape occurred wasn't specific enough to be considered a report. One of the things that Judge Maynard pointed out was that he had presided over many cases in the past where a young victim especially may have used it.
Wasn't part of the problem that the reporter, we'll call her friend, didn't actually use the word rape?
Well, that's not necessarily true, Your Honor. So there is a point where so CH was the one who went to the police to initiate the report. What CH says in her testimony is that she told the detective that the same things happened to LZ. So this is after she provides a very detailed explanation of everything that she says happened to her, including penetrative sexual intercourse. And then what she says to the detective was the same thing happened to LZ. And on cross-examination, the detective said that her understanding of CH's comment was, she took it to mean that LZ had in fact had sexual intercourse with the defendant. So this is a situation where the detective didn't think that there was any ambiguity. And again, when we look at the context, right? So again, this wasn't a one-off from a child who, you know, for lack of a better word, says it didn't know any better regarding what the term rape meant. This was coming from a victim who literally just explained in detail what kind of sexual conduct took place. And then again, to her response was the same thing happened to LZ. The issue that we have.
Is there a difference here between the rape count and the sex abuse of a child count?
Well, yes, there is. I mean, when we talk about the statute of limitations and regarding the report, what I would say is that the report would trigger the statute of limitations in both of those charges.
Let me
because
ask
the-
you a detailed question on that
Sure.
and then get the response. You're right that in the initial part of her testimony, she says the same things. She puts an S on that. It's plural. But then as the examination continues, there's the question that's asked of her whether she'd reported to Detective Porter that the other person had also, quote, had sex with Mr. Begay. And she says that that's so. And as I read this, I'm kind of struck by the potential dissonance between those two. And if we focus on the latter, it seems like she's reporting rape, but she's not specifically reporting the digital penetration. And if she's not reporting the digital penetration, I'm wondering if the outcome here is that we would affirm on the one, but not the other. Walk me through that.
Yeah, and I can see where the court is coming from with that comparison. And what I would say is that again, what we would go back to look at is what was included in CH's initial report. And so yes, she does talk about the sexual conduct, but again, she gives other descriptions in this detailed report to the
Does she
detective.
ever do we have a place in the record in which she ever specifically referred to digital penetration vis-a-vis the other person? I may have
You
missed
mean,
it,
does she ever specifically say that the defendant
Should I?
digitally penetrated LZ
Yeah.
just like he did me or something like that?
Right.
No, not to that specificity.
So if we don't have her saying or even directly hinting at digital penetration, but we do have her saying, quote, had sex with Mr. Begay, then why isn't the outcome different vis-a-vis those two counts?
Again, I think that what we would go back to is CH's underlying report included details regarding much more than just sex. And so when she uses a word like she has the same experience, she's experienced the same things, I think that goes beyond just the rape and would include other sexual conduct as well. One of the other things that I think is interesting to know is that CH says that she had she doesn't necessarily define it as a relationship with the defendant, but they had spent time together on multiple different occasions, which again, I think is indicative of sexual contact happening on multiple occasions as well. And I believe that's what CH mentions to the detective. So I think that when she says that, hey, there's somebody else who can testify that the same things happened to her that happened to me before they happened to me, I would say that would be more inclusive of just a single rape count and would include other sexual conduct as well.
That puts law enforcement on notice that there might be digital penetration, even though she doesn't say anything about digital penetration?
Well, again, she refers to lots of different sexual conduct, right? So I think here's the thing that I think would stick out for me, or why we would be able to do include all of that, whether it's the sex abuse or the rape charge specifically. Again, CH's testimony was that there was both sexual abuse and sexual intercourse with her. So why does that cross over to LZ? Again, because she says the same things happened to her. Now, would it have been nice if the detective had asked her to elaborate? Absolutely. And would it have been nice if the detective had followed up with LZ specifically and asked her these questions? Absolutely. But can we say very affirmatively that the police were certainly on notice that there was some sort of criminal conduct that occurred between the defendant and LZ? Absolutely. One of the reasons
Does it matter that CH didn't give a date on which anything happened between Mr. Begay and LZ.
Well, she didn't give a specific date, but she did say that it happened before it happened to her. So what we can determine from that is we know what LZ's age is. We know that any kind of sexual conduct that CH is reporting occurred prior to the conduct that CH
That's
occurred
true. So,
herself.
but we know that LZ was about to turn 15 at the time of this report. And it matters whether she was 14 or 13 at the time this conduct occurred, right? In terms
Absolutely.
of which crime would ultimately be at issue.
And
That's what I'm getting at. So the report isn't specific enough to include a date. Does it matter that the detective at that moment doesn't know if we're talking about something that happened to a 14-year-old or something that happened to a 13-year-old?
Obviously it does in the grand scheme of things, and whether someone is charged with rape or rape of a child, or I should say unlawful sexual conduct with a minor versus rape of a child. So from that perspective, it absolutely matters. However, when it comes to the report, what Toombs states is that the report gives specific criminal elements of the charge or the criminal conduct. And so even though the victim's age would certainly be factored in there, that's not necessarily required to put the law enforcement on notice or of a
I guess
report.
the question is, does law enforcement have to be on notice of a specific crime or just that criminal conduct occurred?
Well, in this case, I think that we do have, well, maybe you can
Right.
elaborate on
If
that
law,
for me,
if
Your
law
Honor.
enforcement knows that they've got information sufficient to at least potentially charge either rape of a child or unlawful sexual conduct with a 14-year-old, whatever that one's called. In other words, they know it's either crime A or crime B. They just don't know which one based on this report. Is that enough?
I would say yes, it is enough because again, we have the elements of the criminal conduct, which would be the actual sexual contact, which I think was the issue for Judge Maynard is there enough specificity regarding the actual sexual contact or the allegations that are being made? And again, once what I would suggest is that the report need to be sufficient enough and include enough detail to put law enforcement on notice that a crime has occurred. Now, if they decide to do a deep dive and determine that maybe there was an additional crime or that it was a slightly different variation of that crime, I still think that report would count.
That's kind of where my question is going. I mean, the Green case actually uses a crime rather than the crime, and it seems like you could argue from Green that, hey, if you've got a report that tells
Absolutely.
you he did these facts, he the defendant took these actions, and
Mhm.
those actions constitute either crime A or crime B, I think you could argue that that's enough under Green.
I think so. Yes, Your Honor. And so
Even though the police might have to do a little bit more digging to find out whether it's crime A or crime B.
right, and so what Green suggests or what they say is that the report needs to put the law enforcement on notice of who the crime occurred to, or who the victim is,
What
who the
was done,
perpetrator
who did it.
was, and what occurred between the two. And so without further investigation, right? And I think in this case we have all of those things met without further investigation. Now, would further investigation have led to potentially different charges? Maybe, but there's certainly enough here to put law enforcement on notice. One of the things that I'd point out is,
Well, okay,
oh.
but when this interview ends, officer, what's the last name of the officer? Porter.
Yep.
Officer Porter, doesn't know which crime to charge, does she?
She does technically, in the sense that she could say CH just reported sexual or that the defendant had sexual intercourse with LZ. Therefore, that's a crime based on LZ's age. Now, one of the things that I think is interesting as well is that the detective, when she's actually speaking with Mr. Begay, she tells him, hey, I know about LZ. I'm going to call LZ. I haven't been able to get a hold of her yet, but I'm planning on it. And so there again, she knows enough about what happened to tell the defendant that she knows he also had sexual intercourse with LZ. So from that perspective, I think that there's clearly enough information for her to move forward with charges if she wanted to. Obviously, I think that there should be more investigation. One of the things that I would point out, though, to this court is in preparing for oral arguments today, I listened to the oral arguments in Toombs. And one of the hypotheticals that the judge put forth in Toombs that I thought was very telling is they asked the attorneys if a very broad term like molest would be enough to be the report of a crime. The reason I say that I think that's very telling is because I would say a word like rape or having sex with, or he did the same thing to LZ as to me after giving a very detailed account, is far, far more descriptive than a term like molest. And so if the court was on the fence about whether a term like molest, which could mean anything from bugging your little brother all the way up to a first-degree felony rape of a child or anything in between, they were saying, well, is that specific enough? By comparison, we have far, far, far more specificity here. So again, we believe that Judge Maynard made the incorrect decision with the denial of the motion.
Before you sit down, you're at zeros, but I did want to make sure that I asked you a question about the second green factor before you sat down. The state in its responsive brief gave us as an alternative basis for affirmance, the second factor, which
Yes.
turns in part on whether the person speaking had the intent to report. You didn't file a reply brief. Two questions, and I'm wondering if I could get your quick response. One, by not filing a reply brief, did you waive the opportunity to respond on that factor? And two, if you didn't, what's your brief response on that factor?
Well, I don't believe that it needed a reply because that wasn't at issue from the interlocutory appeal. Judge Maynard specifically said he was only ruling on the third point of the green.
Once they give it to us as a basis for affirmance.
Well, and to that point, Your Honor, in response to that, what I would say is I would refer the court back to again the detective's very clear admonition to CH when she says, if you know about any other unlawful conduct that this person has had, you have an obligation, a duty to tell. It's the law to tell me what occurred. And that would be in the record. It'd be.
But I take that point, but just pushing back on it, the language that the Supreme Court used in green was whether the person, quote, intended to notify a law enforcement agency that a crime had been committed. And she does say that this was not her intent. She very definitively says, no, I'm not intending to do this. And so how do we say that a factor that turns on her intent is satisfied where she specifically says that she does not have the intent that the Supreme Court said she had to have?
Yeah, I think that you need to look at the comment that she made in the context in which she made it. And in that context, what she was referring to, she wasn't going to the police station to report the crime that happened against LZ. She was going to the police station to meet with the detective to report a crime that occurred against her. However, when the officer or when the detective Porter said, hey, are you aware of anyone else who is a victim? At that point, now she has the intention to make that report regarding LZ as well. So again, it doesn't matter that, 2 hours before when she initially went to the police station, she was only planning on making this report regarding herself. Once the officer asks her about LZ, clearly she intentionally gave her that information. She intentionally gave her LZ's name, her date of birth, her phone number. So it wouldn't be like an excited utterance where she just let it slip that this happened to LZ as well. There was a clear shift in the conversation at that point.
She gave the date of birth?
I believe that was the case. Well, so in the notes from the officer, she has handwritten notes that has LZ's name, date of birth, and phone number. The detective didn't recall how she got those. So that would be an assumption by me that she must have gotten them from CH. But to your point, Your Honor, that wasn't exactly what the detective said. She just had them handwritten in her notes of the report.
One more question for me. Do you have
No,
follow-up?
I'm good.
Does it matter where CH learned of the information? In other words, reports could come in of varying quality, right? Somebody could just have heard a rumor or watched a news report on TV or something and come in and told this to a law enforcement agency. Here, though, CH apparently learned this directly from LZ
Yes.
during a personal conversation. Does that matter?
I think it matters significantly, especially when we look at this case in comparison to the Toombs case. In Toombs, it was a neighbor who had been told by a grandmother that the victim had gone to the farm with Toombs and then had been bathed and brought home, and so suspected something may have happened. And in that case, that's clearly rumor, suspicion. She's basing what she assumes may have happened based on Toombs' prior conduct. In this case, where we have a very specific account from the victim directly to CH, I certainly believe that takes us from the realm of rumor and a potential something that could happen to real knowledge of something that could be
Do we
reported.
have anything in the record that indicates that CH told officer that she'd heard it firsthand rather than somewhere else?
Yes, in her testimony on both direct examination and on cross examination, she makes several references to what she had said to the detective. One of the things I'd point to on a record 135, CH said that I mentioned to the detective that there was another girl also that could testify that the same things happened to her. So not only did CH, do we have on the record that CH got that information
Yeah,
directly from LZ also?
We know how CH learned the information, and we know that she reported it to the officer. I'm not aware of anywhere in the record where we know that CH told the officer how she knew it. Do you follow my question?
Yeah, I think that makes sense. And
if that's true, that we don't have that in the record, does it matter?
Not in this case, because we also don't have anything to the other end of the spectrum, right? So we don't have anything that says in the record that says this was pure speculation by CH that maybe, LZ happened to hang out with her. So it
To the
was
contrary, we know how CH learned it.
Correct.
And that I think works in your benefit, but what seems to be missing here is any indication that CH told the officer that that's how she knew it. So put yourself in the officer's shoes. Does the officer know this is rumor, or does the officer know that this came firsthand?
And again, what we have in the record is that the officer doesn't really recall much about her interview or her conversation with CH, and so we don't know. And quite honestly, I don't believe that has a huge impact here in this case, because the detective still had plenty of information to be put on notice, and no reason to believe that was just a rumor or wild speculation based on what she did testify to at the hearing.
Well, she seemed to find enough credibility in it to note name, date of birth, phone number. My
Correct.
own guess is that after the discussion with CH, she did some research and came up with the date of birth and the phone number rather than CH just somehow knowing that off the top of her head. But the detective was enough impressed with the report as to make those notations, suggesting at least an inclination to follow up.
Well, she did follow up with Mr. Begay.
Correct.
Just not with LZ.
And had she followed up with LZ, I think we'd be having a very different conversation right now. I believe that's all my time, unless the court has any other questions for me.
Okay. Thank you.
Thank you.
All right, Mr. Nelson, we look forward to hearing from you now.
I'll need this.
Good morning, Your Honors. May it please the court, Connor Nelson for the state. So I'd like to begin with the second element of the green test, which Judge Tenney mentioned. There was no reply brief filed, and so the state's ability to respond to anything that has been said or will be said in the rebuttal has been significantly impaired. So as a matter of appellate procedural fairness, we're in a position where the state has had no real opportunity to respond to any arguments made on that second point.
I wondered about that, and I'll confess I didn't have the opportunity to do the Westlaw search on this. I'm wondering if you have a case offhand on that. But as I understand the posture here on that particular factor, you've raised it. It's not a factor that the district court ruled on. So his opening brief is appropriate. He addresses the factor the district court did rule on. You've raised it as an alternative basis for affirmance. He doesn't file a reply brief. Is this outright waiver by not filing a reply brief, or do we still have the ability to grapple with it? Do you have any case law on that, or any thoughts on that? Because that's something I'm thinking about.
I do have some thoughts. I don't have any precise case law. As a matter of being raised for the first time at oral argument, we do know the cases don't permit that kind of information to come in or be
Although to be
considered.
fair, he's not raising it. I mean, he's just responding to the thing that you've raised, right?
Yeah, you guys respond all the time to stuff they put in the gray brief.
Well, that's because we have to at oral argument. That's our
Right.
only
That's
procedural
what
option.
oral argument's for, isn't it?
As to responding to what's already in the brief, yes, but it's not an opportunity to raise new material. The cases are clear on that point. So it's kind of a procedural ambiguity.
Yeah.
But we do raise it as an alternative basis to the court's ruling. And under the green test, interpreting the statute of limitations here, you need all three of those elements to be met for something to qualify as a report.
Well, for I guess for my benefit, can you just respond to the argument that he's making now, which sort of had already occurred to me? Sort of, it seems intuitive that the intent someone has in making a report should be, we should think of their intent at the time they're actually making the report, not at the time they got in their car and drove down to the police station that day. Let me ask a better question. So CH's intent in driving to the police station that day and going down, sitting down with Officer Porter was to report a crime that had happened to her, right?
That's correct.
But by the time at the end of the interview, when Officer Porter asks her a direct question and says, hey, you're obligated under the child abuse reporting statute to report anything else you know that he might have done. What do you know about that? Her intent in answering that question seems to be clearly aimed at reporting a crime that happened to somebody else. And so why shouldn't we think of intent sort of more granularly in terms of the moment in time in which CH answered that question, rather than more broadly in terms of when she went down to the station that morning?
I have two levels of responses for that. First, we should consider her global intent as why she's down there in the first place, because that informs why she's having the conversation with the detective. But to the more granular point, we know from that exchange that the police are initiating that conversation, and CH is quite reluctant to give the name or even go into the allegations specifically. She's raising concerns about
Why does it matter?
confidentiality.
Why does that matter analytically that the police are initiating?
It matters because the police are investigating another alleged offense.
Let me ask you a hypothetical, and just to make sure that I understand the contours of your position. Suppose that a woman makes a 911 call, tells 911, my husband's beating me, I need your help. Come, please. Officers show up to stop the sort of ongoing domestic violence. They pull her aside, they're interviewing her, and officer asks her, hey, has he done anything else bad to you? And she says, yeah, he raped me yesterday. And the officer says, tell me about it. And then she proceeds to describe a classic rape. I don't want to put words in your mouth, but if I understand the position that you're taking with respect to that factor, you're saying that would not be a report of a rape because she didn't intend to report the rape. She's just responding to questions. Do I have that right? And if so, why would the legislature intend that?
Well, I think it can distinguish your hypothetical a bit from what's happening here, because that's a more generalized question and the information is being volunteered from the witness. Here we have some expressions of reluctance from the witness or from CH. She doesn't want to give this information up.
But she finally does. And so the question is, what is her intent in giving that information? That intent is specifically the officer tells her, look, you have a legal obligation to report this. So she does. The intent then presumably would be to comply with that legal obligation to report this, wouldn't it?
But it's also the intent to report an offense or a crime. And so we have to consider that as the purpose. Is that the reason she's giving the information up? And
I guess I'm just struggling with that conceptually. I mean, I know that obviously we're starting with the plain language of the statute of limitations here, but I'm trying to figure out why the legislature would intend to say the statute of limitations does not run even when officers are given direct information about the elements of a crime, simply based off of what was in the reporter's mind as they were driving to the station. I'm just trying to work through that. So walk me through why it would make sense conceptually to say that telling officers, hey, this exact thing happened to me and this exact thing is a crime, does not qualify as quote a report of an offense simply because the person was intending to do something else. I'm trying to work through that. Why does that make sense?
It makes sense because of the reasons Green identifies as why we have a reporting statute of limitations. And it's to protect victims' ability to bring cases when they're ready and to avoid these inadvertent disclosures or any kinds of secondhand reports. If you look at Green particularly, you see there's a couple of alleged report examples going on and some other communications the defendant alleged it should have put the law enforcement on notice. But the Green court does not credit any of those interactions, both because of credibility and also because of the reasons why that information was being presented. And also we can look to what this court said in the McCamey versus State case.
So even if the reporter tells law enforcement everything that law enforcement needs to know, walks through the elements of an offense, gives them all that information, we're still not going to regard that as a report of the offense because of what the reporter did or didn't want. Is it? Okay.
That's correct, because that element has to do some sort of analytical work. Otherwise, it wouldn't be there. And I also just direct the court to McCamey versus State. The district court actually considered the intent of a probation officer in communicating with law enforcement some suspicions about some alleged possible molestation from a probationer on a minor victim. And paragraph 16 discusses this directly and this court said, instead, the district court found that the intent of the communications was to spur investigation into a suspected offense based on McCamey's background and apparent living arrangement with a person under the age of 18. And so even though that wasn't the deciding factor in McCamey, it was still considered by the district court and weighed against the defendant in that case. And so the communication from this probation officer wasn't for the intent to report any specific offense. It was for the intent to alert to possible offenses. And those aren't the same things under Green.
It seems to me that element does a fair bit of work already. Like it tends to account for situations where something's sort of mentioned in passing or something crosses a law enforcement officer's desk where nobody's really intending to report a crime. The information just happens to end up in the possession of the law enforcement officer. But here, where the officer says, you have an obligation to report a crime, what do you know? Answer. It seems like the intent in answering that question is to report a crime. And I guess I'm having a hard time seeing why that's not the case.
Well, I'll just go back to our earlier discussion about the global intent informing the specific information later and her reluctance to give that information up. And at that point, the interview is cut off. So we don't really know much beyond what the interview notes say. So we don't know the tenor. We don't know if the detective needed to press for more information, ask more pointed questions. And so based on what we do know from this interview in the protected record, there's expressed reluctance to give up the name for fear of breaking confidentiality.
You can intend to do something reluctantly though, right? I mean, or I think I've got my adverbs actually in the wrong sequence there. You can do something even if reluctantly, right? So the fact that she's reluctant to give up the information doesn't mean that she was doing so unintentionally.
I
Fair?
think it informs what her intent is, just given how little we do have about her intent. But we do have her clear statement from the evidentiary hearing that it was not her intent at all to go and report a crime. And that's the intent she has to have under Green. I think
Let's move to the third element if we could. The question is, I was asking your opponent about the information here seemed specific enough to indicate to the officer that a crime had been committed, but not necessarily which one. And I asked him if he thought that mattered. Let me ask the same question to you. Do you think that matters?
Well, it certainly matters for the statute of limitations because the statute uses the language, the crime. So we need something more specific, and that informs the Green discussion of wanting heightened specificity about what's being reported.
I mean, there's a little bit of, I thought that would be I thought that question would get asked and I thought that would be your answer, but there's a little bit of a disconnect between the statute and the verbiage that Green uses, because the statute says that the statute of limitations runs, quote, within 4 years after the report of the offense. And you're right, it says it doesn't say a. But then when Green conceptualizes this, the factor at issue says that we're looking to when they, quote, actually communicate information bearing on the elements of a crime, as would place the law enforcement agency on actual notice that a crime has been committed. And I'm not totally sure what to do with that disconnect, to be honest. So earlier you were really playing in heavily on the language of green, but if we play in heavily on the language of green, we're looking at quote a crime, whether a crime has been committed as opposed to this particular crime.
I
Right.
agree. There's a little bit of disconnect in the language there, and some of the previous briefing on this issue has tried to grapple with that. And so just to keep the response short and sweet on this, because
I'll take your
we could
time.
spend a long time.
Yeah.
Just as a matter of statutory interpretation, that's the exercise green is engaged in. And so we have to give the words in the statute meaning. And
That's a very awkward position for us, though.
Right.
To, in essence, say the Supreme Court got this wrong. In interpreting the statute, they used the wrong article adjective. That's their mistake. And so we're going to follow what we think the legislature meant rather than what the Supreme Court actually said. It's much more our natural inclination to sort of toe the line set for us by the Supreme Court rather than say pish posh, the Supreme Court was wide of the mark there, and go back to the plain meaning of what the legislature seems to have said.
it's a difficult question, and I'm not sure I can give you the best response, just given there is a difference of wording there. But I think we have to keep in mind what the Supreme Court's purpose was, and its purpose was to interpret the statute. It goes through the discussion about what it considers the plain language of the statute. And so I think that just might be a little slip up or a little indiscretion or a little imprecise language used to articulate what it means.
In other words, they got it wrong.
I'm not saying they got it wrong. I'm just saying they weren't as clear as they could have been.
Okay.
Let me abstract this concept up and come at the same place, but just from a little bit of a different angle on that. It seems like we're going to have a lot of different scenarios in which we're going to have a lot of different kinds of reporters. And one of the arguments between the blue brief and the red brief here turns on the specificity of the language that CH used. And one of the things that you've argued in the red brief is that she could have been more precise, that even when she says, quote, had sex with, that language still wasn't precise enough. But one of the things that struck me as I've thought about this case is, well, what if we had a 5-year-old reporter, or what if we had a 7-year-old reporter, a 10-year-old reporter? They're not even going to be at that level of specificity. They're going to be using words that are more imprecise. And yet I can't imagine that the legislature really intends to say that nothing that comes out of a 6-year-old reporter's mouth is going to trigger the statute of limitations. And so surely there's got to be a scenario here in which imprecise language coming from a reporter still triggers the statute of limitations, right? Conceptually?
Well, the kind of precision we're looking for and the kind of precision that Green expects are the kinds of words that can describe particularized sexual conduct, because those are the kinds of things that are prohibited under the various sexual offense statutes here. And this statute of limitations would apply to all of them.
I mean, I hate to even ask hypotheticals because they get really graphic really quickly, but we can all sort of imagine what we think a 7-year-old describing sexual intercourse would sound like. And I don't think that they'd be super specific. And yet surely if a 7-year-old comes into a police officer's office and uses that kind of verbiage, why wouldn't it be within the purview of the courts to sort of holistically say, well, this is what they were communicating to officers, and the thing that they were communicating is sufficient to trigger this, even if they don't say sexual intercourse involving penis and vagina, even if they don't use that level of verbiage, surely what matters holistically is what's being communicated, right? Or am I wrong on that instinct?
You're right, but it needs to be the holistic communication about particularized criminal activity. And that always has to go back to the kinds of sexual conduct that occurred in the specific case being reported or
Well,
information being brought.
do you agree that the officer at the end of the report, the officer doesn't need to know exactly which crime? Do you agree with that or disagree with that?
I think it needs to be sort of conceptualized like probable cause. Like, is there enough information provided here to give police, law enforcement enough information to base a decision off of? Is there enough here that there's a reasonable basis for it?
Here's a hypothetical for you. You've got a 10-year-old kid who calls police and says, my daddy just shot my mommy and she's dead. Is that enough to report an offense?
Well, it would probably be enough to report a murder.
Is
So
it though?
maybe it was in
Is it though?
self-defense.
You don't know if it's self-defense. You don't know the mens rea of daddy when he shot mommy. You don't know what what crime to charge there. You don't know if it's F1, F2, or even a crime at all. Is that enough to constitute a report of the offense?
I guess to clarify that position a bit, yes, there's probably more details needed, certainly a lot more than what we'd have in this kind of case, where we just have the have sex with no other context to explain what it means as to LZ's case.
But
That's
given the age of LZ, it's going to be a crime, to use the language of the Supreme Court. Sex with someone underage is a crime. Now, it may remain to be seen exactly which crime, and thus let's do some investigation rather than just immediately file an information. But it seems to me that still a report has been made of inappropriate sexual conduct of some sort or another with a minor.
Well, the green standard is information that would place law enforcement on actual notice that a crime has been committed. And green also requires that there not be any more additional
there's a phrase
investigation.
before that, whether it actually communicated information bearing on the elements of a crime, as would place law enforcement on actual notice. So it's information bearing on the elements of a crime, right? So why isn't her saying to Detective Porter that she had heard that he'd had sex with this other juvenile? Why isn't that information that's bearing on the elements of some offense? I mean, clearly having sex with, whatever that means, with a minor is an offense, right?
Well, just going off of that level of information puts law enforcement in an extremely difficult position of having to speculate which charges to do and which charges would be appropriate if multiple charges would be appropriate.
But the same would
There's
be
just
true in
no-
Judge Harris's hypothetical. If you know there's a shooting, a shooting could be everything from aggravated assault to murder or potentially something else. So there's a whole range of
Or
things.
nothing at all?
Or nothing at all, depending if it's self-defense or what have you.
And I'll say my initial response to that question was probably not as well thought out. And so,
No, I've been there. I've retracted answers too. So what's your better response?
so the better response is there needs to be enough information communicated for law enforcement to understand the factual circumstances of what transpired in the specific case being reported.
So your position is that 10-year-old's report that daddy shot mommy is not a report sufficient to start the statute of limitations on that?
Probably not having thought about it more, but I'll just also distinguish that kind of case would probably have a different statute of limitations
It would.
altogether. which is-
That's true. That's definitely true.
There's different policy reasons at play for
For
why.
the purposes of hypothetical, let's assume that homicide crimes had the same statute of limitations that we have here. Your position is that would not be a report to trigger it.
Okay,
Exactly.
let me ask you a really specific question. I know we've kept you over. I apologize.
It's the court's time at this point.
It is. Thank you.
It's
one of
also
the-
counsel's time in the next case, but bear with us.
Yeah.
Thank you.
One of the things that really strikes me about this case, and this is the flip side of a question that I asked Mr. Stewart. You have this initial exchange in which the question, I mean, this is record 132, and this was argued about in the briefs. The question's asked of her, quote, "Do you recall exactly what you said?" And then, after a little bit of sort of throat clearing verbiage at the beginning, she says, quote, "There was someone else that this ... the same things had happened to before me." And she uses the plural. And in context where she had reported sexual intercourse and digital penetration to her, when she says, quote, "the same things had happened to before me," why isn't the natural connotation there that digital penetration and sexual intercourse had happened to this other person? And why isn't that the answer to all this?
It's not because CH really we don't really have a basis to attribute. Well, first of all, that's not the language she actually used in 1998. We have that snippet from the end of the interview, and those specific words aren't used. We only have to have sex.
Well,
So that's all we know for
The
certain.
transcript of the interview ends before we even get CH's response to the question. We don't know from the transcript anything that CH said in response to that. All we have is from the evidentiary hearing that took place a couple of years ago, right?
That's right. And so I'm just making the point, we have to be careful about the information that we're considering here.
I mean, but
Because-
she says under oath at the evidentiary hearing, and whatever year the evidentiary hearing happened, the quote, she told the officer that, sorry, that was not a quote. She told the officer that, quote, "the same things had happened to before me." And I don't know if it would be overdoing it to put a lot of weight on the fact that same things is plural. And so if same things is linking back to what she had told the officer had happened to her, and that included both sexual intercourse and digital penetration, why isn't that just the answer here?
Because that would require us to assume that CH would understand what the same things were, when in fact they are quite different based on the actual report being made in 2021. It's a bit of an information passing game here where LZ says something to CH and then CH says something to law enforcement. And so that's what makes these kind of third-party alleged reports a bit difficult to conceptualize. And the important information, of course, is what law enforcement knows. But in this kind of case, CH even testifies that LZ never described any particular contact that occurred between herself and the defendant. And so there's no real basis for CH to even understand what happened to LZ herself, apart from maybe trying to assume what happened, but we can't really use that as a basis to reverse. It's speculation what she should understand from that. And then we have the additional layer of what would actually be said to law enforcement, which again, as Judge Harris noted, isn't in the record itself. So that would be another degree of speculation of what precisely was said.
Yeah.
Unless the court has any further questions, we'd ask
Okay,
the court to
thank you,
affirm on
Mr.
either
Nelson.
basis we present.
Thank you.
All right, Mr. Stewart, rebuttal?
Just briefly, Your Honor, that I think one of the things that I would point the court to that I found very useful in Green is they do give some guidance about what we should look at in a report when it comes to the detail. So it would be starting in paragraph 42 of the Green decision. It says, while it would be unreasonable to adopt an overly narrow interpretation of an offense, for instance, one that could be satisfied only through reference to Utah code sections, the disclosure of mere clues that the criminal conduct has occurred is not enough. Just as the requirement of a report implies some formality in its communication, so the requirement that an offense be disclosed implies a degree of articulation of criminal conduct sufficient to permit law enforcement agency to conclude that what was done and who did it without any additional investigation or analysis. So from that, I think what Green is suggesting is that it doesn't have to be this uber specific articulation where, for example,
But shouldn't they at least be required to verbalize the conduct that would lead to the criminal charge?
yes, I think so.
And
And
back to the question, we already had the exchange, but she's not saying to the officers anything about digital penetration. And that's one of the two charges, if I got all this right.
And again, I mean, I probably sound like a broken record at this point, but I do think that she gave this overarching testimony of what had occurred to her prior to saying the same thing happened to this other person. So when that overarching testimony
isn't that
includes,
potentially problematic though, because then you're saying the statute of limitations is essentially running for any. I don't want to put these words in your mouth, and I don't know if I'm taking what you just said too far, but it sounds like you're kind of saying that the statute of limitations runs for any sexual offense involving a child at that point.
no, not at all. I mean, it would maybe specifically with LZ and that defendant or anything that had occurred prior to.
So with respect to LZ, would the statute of limitations have run for any sexual offense involving her?
And
Based on sort of
with the
global thing?
defendant,
Yeah.
any sexual offense that occurred prior to, where as long as those sexual offenses would fall within the umbrella of what CH already testified had happened to her. So and I guess the way that I'd look at it is like this: if let's say we have siblings that have been sexually abused, sibling one sits through an intensive interrogation where obviously a lot of a very emotional heart-rending things come up. And then rather than have that victim go through that same process of explaining in excruciating detail that this all happened to the siblings that he loves as well, I think that the legislature should be okay with them saying, everything that I just told you in detail that happened to me also happened to person X. So to answer that question, I don't know if that answers your question, Your Honor, but
I don't know how to respond to that. I think it's an answer. Thank you.
okay. Again, I think in this case, we have a situation where there was very clearly a report by CH regarding the conduct between the defendant and LZ. That report was made in 1998, therefore starting the statute of limitations, tolling the statute of limitations and barring prosecution after 2002. So we would therefore ask the court to overturn Judge Maynard's decision and grant our motion to dismiss. Thank you.
Thank you, Mr. Stewart. Thank you, Mr. Nelson. We appreciate the arguments you've made this morning. We'll take this matter under advisement and we'll issue a decision as soon as we're able to do so. Thank you for your arguments today.